grounds for awarding attorney's fees, but it is also this idea that either in whole or in part, or if any action or any part thereof is found to be groundless or frivolous, attorney's fees can be awarded as to that part. So in this particular case, and again, the award of attorney's fees is beginning on page 67, the court found that one of the claims, which was actually voluntarily dismissed, then incurred attorney's fees for having brought the claim to begin with, even though it was dismissed. The fact that the respondent had to spend time responding to a claim, even if it was eventually later dismissed, still incurred an award for attorney's fees. So if you're going to bring a complaint and you're going to outline different claims or allegations, be aware that each one of those individual claims is going to be subjected to its own independent analysis as to whether it was justified or whether you may be subject to attorney's fees. And that's obviously very different than the attorney fee standards that are usually applicable in civil or armed court proceedings.
Yeah, and another piece that's important here in the language of this statute is this is actually a two-way street. So the attorney's fees can be awarded back and forth to either party. So even though the two examples that we've just been given are attorney's fees awarded against the complainant for the respondent because a certain part of the complaint was dismissed, the statute actually says that either party could recover a portion of their fees based on bad behavior of some sort by either party. And so, for example, things like unnecessarily expanding the proceedings by improper conduct, including discovery abuses, those are things that could be done by a respondent in a case. And the reason we don't have any examples for you is because we really don't have any examples of attorney's fees ever getting awarded against a defendant. But you can think of, right, I mean, what if you have a, stipulated, there's facts out there that are super obvious, but for, through discovery or through the process of this hearing, a respondent is being extra intransigent. It's like, no, come in here and I want you to start off with witnesses proving that the sky is blue and we live in America and let's start from square one. I'm not going to concede anything. I'm not going to do whatever. And I think that there's, parts of this statute that could be used in such a case and to say, hey, maybe there should be attorney's fees or at least partial attorney's fees maybe awarded to a complainant who has to deal with that and maybe even overcome that and win the ultimate case. And remember, the complainant doesn't get any of these fines. This statute actually is written to go both ways.
I'll make another observation because we've seen most of these awards for attorney's fees when they are awarded are on the basis that the claim itself was groundless or frivolous. But it's important to note that 145, 111.5 has an interesting operative phrase. It is not just that the complaint lacks substantial justification, but it is or that the action or any part thereof was imposed for delay or harassment. So it is an either or. You may still win the case, but if the reason or the motivation behind that complaint was substantially vexatious or intended to harass as opposed to seek clarity and transparency in elections, that is also the basis upon which an administrative court could impose attorney's fees. And courts have upheld this, particularly this case involving the imposition against campaign integrity watchdog and its, quote, alter ego was sustained by the Court of Appeals. An attempt to appeal this decision and the ruling and the imposition of attorney's fees was upheld by the Court of Appeals in an unpublished decision published shortly thereafter. So that is useful for practitioners to be aware of in the context of recognizing attorney's fees is something that you may run into. Let's talk about appeal, because if you don't like the outcome of an administrative court, or there's a issue or a challenge with the way a particular administrative court has analyzed the law or laid out as sort of a standard on this, either party can appeal pursuant to 24.4.106 paren 11 and Colorado Constitution Article 28, Section 19, to provide for an appeal to the Colorado Court of Appeals. It is a very quick process in terms of filing your initial notice of appeal. It has to be filed within 49 days after the service of the final order entered by the agency, or in this case, entered notify the administrative courts. So 49 days is the timeline for filing your notice of appeal. And if you are going to file that notice, there's an example of what that notice looks like in your pleadings example. So that begins on page 87. Is a good example of how a notice of appeal gets filed. This one cites specifically the CIR 4A, but others appeals will cite to all those statutes that are applicable, Article 28, Section 9, as well as CRS 24.4.106.1 in terms of the basis for the notice of appeal. But you'll lay out, again, description of the nature of the case, questions. This is a good appellate practice. And for those of you who do wish to file an appeal, I would note that there have been some recent changes to the appellate rules governing case citations. So for some of you who might have been used to filing cites or different formatting issues, the Court of Appeals doesn't have a lot of wiggle room. If you cite the thing wrong, they'll kick your pleading back and potentially reject it. So be mindful of new pleading standards, the formatting standards for Court of Appeals cases if you're intending on filing that notice. And then you have to certify the record, and there's an example in here of how that process works. You provide a copy of the administrative court's ruling to the judge. You also then designate the record, and then the administrative courts respond in terms of providing a certificate of record laying out everything that was in the case file. And this is also kind of useful from a practitioner's perspective to see it. This is all the stuff that essentially was in one case involving this particular complainant was then appealed. So you see the notice of the hearing, the second notices, the motions to quash. You sort of see the way the case kind of rolls out by reviewing what the record on appeal looks like and what's part of the administrative court record. And then the process moves forward, as you might see in an appellate proceeding, with an opening brief, and then a reply brief, and then various motions back and forth, and ultimately, hopefully, a decision as to whether the law was properly identified. And then, again, we do have a couple of examples of Court of Appeals cases that have been further appealed up, particularly one that was pending that impacts practitioners in that, at least for a short period of time, if you were providing any pro bono legal services to candidates, you would have been making a contribution. Unfortunately, in that particular case, and that Court of Appeals decision was stayed with good action by the Secretary of State's office and the Attorney General's office to prosecute that.
So one wrinkle on this that I want to highlight here, and as Ryan pointed out, it's a 49-day period to appeal. And then presumably if that time lapses and you choose not to appeal, then okay, we're done. We've got an ALJ order, you're supposed to, let's say the respondent loses, and so they're supposed to file something, pay a fine, whatever. So the new wrinkle is what just happened recently. If you want to look at page 112 of your packet, this is, CLE at its best. So it's an 11-day-old ruling from the 10th Circuit that you guys have here. And although I caution you, it's an unpublished order, but I'm giving it to you guys because it's important. And basically what happened is this is the idea of the use of federal courts to challenge campaign finance enforcement proceedings that are happening at the state level. And so basically the short version of this saga is in that 2014, my organization brought a campaign finance complaint against two organizations, Rocky Mountain Gun Owners and Colorado Campaign for Life, in this process we all just walked through for failure to file. And while we were negotiating with them and extending our 30-day hearing date and working back and forth to stipulate facts, which we did, stipulated facts, all this stuff, they also, before the hearing started at the Office of Administrative Courts, they filed an action in U.S. District Court, basically a federal constitutional challenge, both as applied and facially to the electioneering communications laws and things that we were filing the enforcement action under. And so we went through preliminary injunction, TRO type of proceedings at the district court. In that brief window, we continued the ALJ hearing another month to give time to figure out what was going on. And basically on the basis of a younger abstention, the federal court said, you know what, I'm not getting involved. State court, do your enforcement proceedings. I'm not doing a preliminary injunction to stop the state court proceedings, go forth. And so we did. So we went forth, we had our hearing, and got an ALJ order ordering them to file and pay a fine and such. As soon as that, while that was happening, or once that happened, then motions to dismiss were filed in the federal court, and I should say the federal case named not only our organization. This is when I say I'm usually not a respondent. This is one of the few times someone sued me, but in federal court, but also the Secretary of State's office, because it's a challenge to the statutes, right? And so, motion to dismiss again on these same grounds, that the state enforcement proceeding is going on, abstention, and federal court should dismiss the case. Long story short, the appellate timeframe, the 49 days, expired, and these organizations did not appeal the order at the administrative law judge, but they considered or continued to keep the district court case alive. And the district court, after the time frame had passed, dismissed the case in district court on these same grounds of abstention. They appealed that dismissal to the 10th Circuit. What you have in front of you is the 10th Circuit basically saying that that ruling by the district court at the end there, dismissing the whole case on younger abstention grounds, was improper, because by then the state court proceedings were all done, because there was no appeal running. They had not chosen to appeal. The ALJ decision was done. So the 10th Circuit has kicked this case back to the district court to do some findings. Now they'll be briefing about mootness and all sorts of other issues. But the real question, and I don't have an answer for you because we don't know until the district court and possibly the 10th Circuit again tells us, is whether or not there's this possibility that a case isn't really over when it's over in what we just went through. Because if there's a way that a party can go through the state process, choose not to appeal, and instead basically take another bite at the apple through some sort of federal challenge, we might be in a whole new world. And everybody is going to have to deal with that. So I don't know where that's going to go, but being that it just came out, I felt we couldn't pretend it didn't exist. And we'll have to see. So that will be a case to watch. I'll expect hopefully a district court ruling in this upcoming year, and then I'm sure it'll go to the 10th Circuit again. But something to think about when, this morning we talked about all these First Amendment implications and the as-applied challenges and the way that these cases getting worked out in the state enforcement system. So now we're going to have a jurisdictional tug-of-war between the federal courts and the state court system about who's really deciding these issues and where the final decisions are going to lie, and who's going to give abstention or not to those processes. So stay tuned on that point.
As it relates to that kind of jurisdictional question too, I'll call your attention to some information in the packet. That's a copy beginning on page 82 of a Court of Appeals decision, Division 1, involving the enforcement of attorney's fees. And that's kind of an interesting case. We won't delve in it too much, but important to note that the district court is declining jurisdiction to be able to enforce attorney's fees in the case of campaign finance complaints. They basically say, nope, that's the purview of the Administrative Law Court to issue the order for attorney's fees, and the Secretary of State to enforce those fees and fines, not the district court. So in terms of the court here declined to convert that judgment into an action and a judgment from the district court. It's kind of an interesting wrinkle, and that was a case involving the Gihon and the responding parties. The respondent was Don Cave and Jessica Peck, who was an attorney. The court does, however, note in its decision, especially in the concurrence, that while Cave was a private citizen and may not be subject to certain ethical rules governing following an order from the court, the attorney certainly is, and the attorney needs to be mindful of her obligation to follow an appropriate order issued by a court, even an administrative law judge court, and pay the fine and penalty appropriately assessed. So something to be mindful of in that case. But it goes to also the question of jurisdiction and who enforces those fines or penalties, including attorney's fees.
Right, and that brings us to kind of our last bit. In addition to questions you guys have, Brian and I talked about maybe chatting a little with you about fixes or sort of ways that maybe going forward some of the things in this enforcement process could maybe be improved from different perspectives. There has been a legislative fix already proposed to the case he was just discussing about the enforceability of attorney's fees. It was gonna be an amendment to a bill last year, it didn't go forward, but I anticipate seeing it again, this session. So that might be one of the legislative fixes, that you might see coming forward, that would nullify the effect of this case. But I know there's other things that Ryan and I were talking about, that might help everyone who practices in this area, people who are trying to comply with the law and those who are trying to make sure that voters get the information and the law is, followed. The Secretary, one of my main points is the Secretary of State, as was mentioned earlier, the tracer system and the Secretary of State's office is very good at enforcing the late reports. As was mentioned before, you're 1 minute late, you get a ding, boom, it's going forward. So you don't see people filing necessarily private enforcement actions at the ALJs for late reports, because that's something that the Secretary of State does have jurisdiction to do enforcement of these laws. That's something the Secretary of State's office is doing. I think there is a real opportunity for the Secretary of State's office to move kind of a step beyond that to some of these other technical violations that we're seeing being used maybe in a gotcha manner, maybe for where technically you're correct, but it's really brought for harassment if you want to talk about motivation of complaints. I think some of the technical errors that happen in Tracer, there are ways that maybe like TurboTax, you could get some sort of flag or you can't go forward or something along those lines. From some of the ones that come to mind that I know of that are honestly technical things that I don't usually file complaints about are things like the employer information for a contribution of $100 or more. That's a field that gets left blank. Something in the computer program, and I won't pretend to know the back end of the computer programming, but something could presumably give you an error saying that field can't be left blank because you just put more than $100. Something like that. But that is something that can be used on day 179 to go after someone because it is a violation. You're supposed to report that, absolutely. So I'd like to see more of those technical errors and reporting errors be addressed through sort of administrative enforcement. And whether that be an automatic ding, like the late filing, or some sort of administrative notice from the Secretary of State that gives an opportunity to cure. I don't know exactly what that would look like, but I'd like to see more administrative enforcement because that, I think, takes it out of the realm of being left to the whims of private enforcement. And then you do have people picking and choosing, and it becomes very selective enforcement on those type of technical violations. And so I think that's, for me, one area that I'd like to see things go.
And to add to that, I actually think there's a window, and despite the language in the Constitution that requires, the enforcement for the ALJ, there may be an opportunity within that 15-day window to provide for the cure by amendment. Because right now the challenge is, and it's a bit ambiguous, every time a candidate committee or a political committee or any kind of political organization files an amendment to any report, you could be making yourself liable for the failure to disclose it initially. And we're starting to see some of those kinds of complaints where they found in reviewing the books and doing an audit of the records, they said, oh, we missed this particular transaction, let's amend our report to add it back in. Then, even though they made the amendment, they're putting themselves essentially at risk. It's almost a disincentive to amend their reports because it then puts them subject to getting complaint.